Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about a letter from the Texas Attorney General. I'll get more on that in just a moment. So, you may not know it, but the Attorney General in your state, or at least in most states, is charged with not only handling appeals in criminal cases and representing the state in litigation. The AG's office is also charged with protecting the public interest. And by protecting the public interest, one of the things, for example, that they do is they monitor charitable organizations. And if you've got a charitable organization that is actually not so charitable, that is spending 95% of the money that it takes in to collect, additional money, if it's not efficient, there are things that the state attorney general can do to oversee those kinds of operations. And so every now and again, things come up where the attorney general feels the need to get involved to protect the rights of the citizens. And an interesting situation has developed like that in the Mallinckrodt bankruptcy. As you may or may not know, one of the things that Mallinckrodt marketed was generic opioids. After the patents were no longer valid on a lot of these very significant opioids, Mallinckrodt started turning out generic versions of these and sold them all over the country. And the plaintiffs in those cases have alleged that contributed to the opioid crisis, and as a result, Mallinckrodt got sued. So that's sort of the backstory here. Since this issue seems to revolve around the Texas plaintiffs, I will restrict my comments basically to the Texas plaintiffs here. Let me explain some of this. A lot of times, the damage that results from a public nuisance, like the opioid crisis, is not something that affects an entire state. A lot of times it just affects the larger cities like Houston and Harris County, or Dallas and El Paso, San Antonio, places like that. As a result of that, those cities and counties have an independent right to bring litigation on behalf of their city or county for the funds that the city and county expend to abate a opioid crisis. As you might imagine, they probably had to put more police officers on the street. They probably had to staff more ambulances. And they probably had a large number of Medicaid patients that they all had to treat. Although mostly that would go to the state, the public charity hospitals in those areas may also be affected. So in addition to private plaintiffs who can bring an action because their loved one have died from an opioid overdose, the law allows the counties to bring actions on their own behalf for the damage that the county has sustained. But a lot of times a county does not have a large legal department, and the legal department that they have is not particularly fluent in the language of litigation. Usually what happens is when the county gets sued, the general counsel for the county will contract with a local law firm to handle the defense. Well, in this case, the county is contracted with law firms to handle their plaintiff's case. And they reached a deal with those counties, and those plaintiffs' lawyers took those cases on. Now, while the private plaintiffs were taken care of in a different lawsuit, and well, not only in different lawsuits, but in a different settlement trust, the Texas litigating cities and counties, along with all the other cities and counties in the country who had opioid claims, were put into something called the Opioid Settlement Trust Number 2. I believe I have the actual name for it here in just a second. But basically, that's where all of the money to abate opioid problems went. And as you'll see in a moment, that has some real import for the letter that the Attorney General wrote to the bankruptcy court in this Mallinckrodt case. While it might be pleasant to think that the county officials are monitoring what goes on in the litigation that involves their counties. In many cases, it isn't. In many cases, they simply get letters periodically from the plaintiff's lawyers explaining what the status of the case is, and they don't go any further than that. As a result, sometimes some mischief can arise when plaintiffs go beyond the parameters that they are given. So let's turn now to the letter that the Texas Attorney General wrote in this case to Bankruptcy Judge Dorsey in Delaware, explaining what the problem is. As you are aware, the Mallinckrodt Plan language explicitly requires that funds distributed by the National Opioid Abatement Fund II be used solely for the approved opioid abatement uses, which do not include attorney's fees, and establishes separate attorney fee funds as the exclusive source for payment of attorney's fees. Despite this clear language, certain Texas plaintiff subdivisions have filed a motion in the Texas State Court seeking to pay attorney's fees with funds exclusively earmarked for opioid abatement strategies, in addition to the funds specifically set aside for the payment of attorney's fees. This is not the first time plaintiff subdivisions have sought such relief in a state court. An Arkansas state court recently entered an order granting the plaintiff subdivisions the right to pay their attorneys with funds that are to be used solely for the approved opioid abatement uses. And the Texas plaintiff subdivisions are using the Arkansas order as precedent in the Texas state court. Because the plaintiff subdivisions have already sought permission from two state courts to improperly pay their attorney's fees, the state of Texas believes the plaintiff subdivisions in other states will continue to seek similar relief in their respective state courts. Basically, what the Texas Attorney General is saying to the Mallinckrodt Bankruptcy Court is the plaintiffs are ignoring the explicit language in your confirmation order. When somebody goes through bankruptcy, one of the things that happens is when the case is entirely wrapped up, there is a confirmation order. And that confirmation order confirms the plan of reorganization. And in that plan of reorganization, it is entered as an order in the court, and disobedience of that order of the court can lead to contempt, among other sanctions. So what the Texas Attorney General is doing here is they're letting the court know somebody is playing fast and loose with your confirmation order, and we believe that a conference is necessary to sort of hash all of this out. And what will be interesting here is there will be a clash between the agreement between the counties and these attorneys and the confirmation order, which requires that all of those funds go to opioid abatement issues. And it's pretty clear that that's not going to happen if indeed some of those funds are going to be used to pay the attorneys. Most of the time, attorneys try to play by the rule of law and try to do things on the up and up. But every now and then, you'll get somebody that good lawyers would call an angle shooter who will try and skirt the process or do something that is outside what has already been agreed to, with the understanding that if he can get a court to order it, it's unlikely to get overturned, or at least it will be difficult to get it overturned. So the Texas Attorney General here is doing exactly what a Texas Attorney General should do in this situation. They're alerting the court with exclusive jurisdiction. Whenever there's a bankruptcy, the exclusive jurisdiction for what the confirmation order controls is with that bankruptcy court, because it's the court that entered the order. What the plaintiffs have done here is they've gone to the local district court to allow them to violate the order of the bankruptcy court. And that is not sound legal practice, and it could potentially get them sanctioned by the state bar, although sometimes that doesn't happen if everybody works this out first. So the lawyers are going to take a little bit of a haircut. They're not going to get their full fee that they would have gotten if they had gotten a huge jury verdict. Rather, they are going to get exactly what the confirmation order says they can get and not a cent more. Sometimes that's a bad outcome for the lawyers, but at the end of the day, bankruptcy is a bad outcome for everybody. Everybody loses in a bankruptcy. The bankrupt party loses, all of the creditors lose. If you have debts that are $10 million and you've only got $1 million in assets, everybody is going to take a haircut in order to get that plan confirmed. And in this particular case, the plan did get confirmed, and people are going to be bound by that confirmation order. So as we get more information on this, I will update this story, but I thought it was pretty interesting that the Texas Attorney General is stepping up and taking the lead on this case on behalf of the cities and counties in Texas who are, because they're probably not paying close attention, about to get hosed. So, if you have any questions, leave them in the comments down below. Like, share, subscribe, you know all the stuff to do. And if you found this interesting, I'd appreciate a thumbs up. Thank you for watching, and have a great day.